Good afternoon, everyone. I'm Rodney Marshall. My topic that was selected was the Violence Against Women Act of 1994. My presentation here is Measures of Improvement, Violence Against Women Act, an examination of ethical responsibilities. The table of contents consists of the original Violence Against Women Act enacted into law, the importance of Native American women, tribal courts and their significance, answering constitutional challenges to Tribal Violence Against Women Act provisions, workplace violence, sexual harassment versus flirting, and a comparison table, an idiot's guide to sexual harassment in the workplace, National Association of Social Workers Code of Ethics, core social work values, knowledge, influence, and power, the Me Too movement, and then a question for discussion. So in 1994, our current president, Joe Biden, was a senator representing Delaware and had sponsored the Violence Against Women Act and began in 1993, going into 94. And the Violence Against Women Act of 94 is a federal law in the United States that protects funding and resources for women who are the victims of violent crimes. It was signed into law by President Bill Clinton in 94, and the VAWA was part of the Violent Crime Control and Law Enforcement Act of 94. It established the Office uh, of Violence Against Women, which in part of the Department of Justice. Former Vice President Joe Biden, then a senator from Delaware, wrote the original draft of the law before introducing it to Congress, where it passed both houses. And the act was designed to raise awareness about the prevention of violence against women and ultimately put a stop to crimes such as domestic violence, sexual assault, and stalking. The act was credited with greatly improving services for women victims of violence as well as programs aimed at educating others about violence against women. Since its passage, the VAWA has spawned several federal groups formed to continually improve protections for women and girls in the United States. And here I just have a brief breakdown of the titles and subtitles that are associated with it. So, the importance of Native American women is significant because the most significant impact violence of this nature has on the demography of women includes lasting issues with physical and reproductive health, along with the mental and emotional state after being victimized. And I have some key elements here that go into the Native American women in particular with some of the abuse that they had suffered, along with some percentages that go into staggering numbers. So, violent attacks have been increasingly high, especially concerning female ethnicities from all backgrounds. But national research clearly pinpoints a serious public health issue for Native American women. A staggering 84% were subjected to violence of some significance throughout the span of their lives, and 90% of pregnant Native American women were subjects of physical, sexual, and/or emotional abuse. Native American women living in the western regions of the United States suffered sexual abuse at a significantly high percentage, 84.4%. Research also suggests differences in the context of violence against Native women. For example, Native women experience higher rates of sexual assaults, including physical violence, weapons used during sexual assaults, and assaults resulting in injuries, and the need for medical care for injuries compared to women of other racial and ethnic groups. Further, Native victims of sexual assault are most likely to report that the offender had been using drugs or alcohol at the time of their assault. In addition, Native women are also more likely to report experiencing interracial violence in their lifetime than women of other racial and ethnic groups. According to Rose, the rate of lifetime violence by an interracial perpetrator was 97% for Native American women victims, compared to 35% for non Hispanic white women victims. The most significant impact violence of this nature has on this demography of women includes lasting issues with physical and reproductive health, along with their mental and emotional state after being victimized, as I had just said. So, tribal courts and their significance. Native American women had struggled to prosecute offenders for many years. Tribal courts were not allowed to try non Native American offenders, even if the crime was committed on tribal lands. The newly authorized VAWA remedied these gaps in justice and safety. And I have another brief excerpt here that I wanted to cover that talks about the tribal victims against or violent acts against women provisions. Uh, Here it talks about after the Violence Against Women's Act of 2013 was introduced, two members of the Heritage Foundation, Paul J. Larkin and Joseph Lupino Esposito, published a paper questioning the tribal provisions' compliance with Article 2 and Article 3 of the Constitution. A decision by Congress to empower tribal courts to enter judgments in a criminal case against non-Indian raises questions under the Appointments Clause of Article 2, as well as the judicial vesting and power clauses of Article 3. Their position is that the Tribal Violence Against Women's Act provisions, as an act of Congress, must conform to both Article 2 and Article 3 in order to be permissible in exercise of authority. Article 2 sets forth procedures for the appointment of federal judges. Namely, these judges must be nominated by the President and confirmed by the Senate in order to take the bench. Article 3 provides the federal judges receive lifetime appointments and prohibits the government from reducing federal judges' salaries during their tenure. Because tribal judges are selected by tribes and not given Article 3's job security, the Violence Against Women's Act 2013 runs afoul of these constitutional mandates. So, what it's basically saying is that there's a conflict of interest there, and I'll tell you why. Article 2 requires the officers of the United States be appointed in a particular way. Generally, only the president, a court, or a head of a department may appoint these federal officers. Larkin and Lupino Esposito contend that the VAWA's 2013 tribal provisions effectively would make tribal judges officers of the United States for Article 2 purposes. This is because they argue the term officers of the United States, as used in Article 2, includes any person who exercises the power of the federal government. Further, they assert the power to imprison an American citizen for violating a federal offense is an archetypical example of the exercise of government power that can only be exercised by a person properly appointed under Article 2. Thus, because the VAWA 2013 is a federal statute which gives tribes the authority to imprison American citizens, tribal judges must be appointed according to the Appointments Clauses procedures. Okay? A very interesting piece of information there. Answering constitutional challenges to the Tribal Violence Against Women Act provisions. The bill added a new provision that would allow non-native tribal courts, which Republicans viewed as unconstitutional despite the opposition. The bill was eventually signed into law by President Barack Obama in March of 2013. The 2013 Violence Against Women's Act included new protections for college students and youth as well as public housing residents. Its new provision allowed Native American tribal courts to take action against non-Native Americans for violent acts against Native American women. Transitioning into workplace violence. You see, we have the Silver Line Foundation here, and it gives some fast facts about one woman killed every week by a partner on average. And nearly 500 women were killed from 2002 until 2012. 1 in 4 women experienced violence. 1 in 5 women experienced sexual violence. And 1 in 4 women experienced emotional abuse by a partner. Sexual harassment versus flirting. This is a comparison table, and At the top left, you see characteristics. In the center, you see sexual harassment. And to the right, you see flirting. Okay, so meaning sexual harassment means making any unwanted sexual advances or signs to another person, versus flirting means any behavior that suggests one is attracted to another in a sexual and playful rather than a serious way. The form for sexual harassment is unwanted and involves actions and advances that make the victim uncomfortable and insecure, demeaning and invading. Flirting. It's a it's welcome in most cases unless it's overdone and the action suggests more of a harassment or sexually inspired, improved self-esteem, wanted and welcome, open and flattering. So the results of sexual harassment could be bruised self-esteem, feeling unattractive, feeling unwanted, and creates bad blood between the parties. For flirting, it makes one feel good, wanted, and attractive if it's moderately done, with no signs of sexual exploitation or gratification. An Idiot's Guide to Sexual Harassment in the Workplace. So here's a little chart. You may have seen these in magazines where they say yes or no and you follow your way through. But I thought this was kind of interesting that they had this here. It says before saying or doing anything, ask yourself, is it related to your work? The answer is yes, then say or do it. If it's no, does it involve touching someone without their consent? If yes, then don't do it. If no, does it involve commenting on someone's appearance? Yes, don't do it. If no, does it involve making a noise in a cat call like manner? If yes, don't do it. If no, say or do it. So, the National Association of Social Workers has a code of ethics. And in the workplace, we see a lot of fine lines between sexual harassment, whether things could be considered sexual harassment, borderline sexual harassment, making someone feel uncomfortable, all those sorts of things that fall under those categories of improper conduct at work. So the National Association of Social Workers, or the NASW, has a code of ethics here that deal in 6 primary tenets, and that's service, social justice, dignity and worth of the person, importance of human relationships, integrity, and competence. And of these 6 tenets, if you go into the NASW link that we have in our assignment protocol there, it gives some explicit details as to what some of these tenets represent. And they updated their code of ethics. And a few of the updates that they did, the sections of the NSW code of ethics that were revised include informal consent, competence, cultural competence and social diversity, conflicts of interest, sexual relationships and sexual harassment, interruption of services and referral for services, and respect, sexual relationships, sexual harassment, 2.07, unethical conduct of colleagues, supervision and consultation, education and training. So, one of the things that I found was interesting is when the Violence Against Women Act was enacted. What it did was is it gave a provision for women to be able to take time off of work, to be compensated, um, to transition, to have rites and passages to still be able to see their children. And it poses a question that we're going to get to in just a moment about some of those circumstances with family environments and when people were working together and living together, and what that would do if one of the sources of income was reduced due to a domestic violence call. But more importantly, what's critical in the VAWA Act is it enhanced 2 components for routine domestic calls. When police officers came to the house for a domestic dispute, historically what they would do is, let them work it out. It's a private matter. And after 1994, under the Clinton administration with Senator Biden sponsoring the bill, it forced police officers to take a closer look at the domestic violence and get to the root issue of whether or not they were leaving someone in danger, walking away from there without a collar. So they would make more arrests be a mandatory arrest or removal from the property or premises, at least anything for the evening. And when they incarcerated the individual, the assailant, the more aggressive of the two, in most instances being the man, the state at that point could pick up the charges and move forward with prosecuting for domestic violence disputes and issues, even when the crime victim didn't show up to court. So they didn't have to be present, and the state could pick up the charges and move forward with it. So that was a key element that I saw there in the act. So, core social work values: service, social justice, dignity, worth of a person, importance of human relationships, integrity, and competence. This is just another breakdown, something else that I had found that gives a little bit more issue to the six tenets that we saw there in the previous um, slide. So, knowledge, influence, and power, the Me Too movement. This is a great example of change and enactment and courage and strength. The Me Too movement was started by Tarana Burke in 2006 after her own experience with sexual violence. And she was encouraging women to step up and to speak out, on behalf of ending all violence towards all individuals, and particularly with women being assaulted. So I pose a question to each and all of you. Has the Violence Against Women Act and the mandatory arrest protocols, when responding to domestic violence calls, created a stigmatizing aspect to the abused women, reluctant to remedy their circumstances due to their significant others being arrested and losing their job? I encourage each and every one of you to take a little bit of time, look into the Violence Against Women Act, take some time and look at the duration of violence that Native American women had endured. Two movies come to mind that I had listed in the paper: Killers of the Flower Moon and also North Country. Take a look at those if you get an opportunity. Thank you so much for your time listening to me present about Violence Against Women Act 1994. Have a lovely day.